On January 18th, 2022, the National Indigenous Women's Resource Center filed an amicus brief in the United States Supreme Court in United States v. Merle Denezpi. On this episode of Speaking Our Truth, Podcast for Change, we'll dig deeper into this case and what this amicus brief is all about. Hello and yate, everyone. Welcome to Speaking Our Truth, Podcast for Change by the National Indigenous Women's Resource Center. I am your host, Merle Denezpi, and I am Dene. I'm excited to introduce our guest with us today, but before we get started, let's hear a word from the NIWRC.
NIWRC's VAWA Sovereignty Initiative helps protect Native women by defending tribal sovereignty and the tribal provisions provided by the Violence Against Women Act. Donate to the initiative online at niwrc.org/donate.
I'm excited to introduce our guest with us today, our sister, Mary Catherine Nagel. Mary is a citizen of the Cherokee Nation, and she's a partner of the law firm Pipestem and Nagel. She's also counsel to us here at the National Indigenous Women's Resource Center. Mary has an article in the February 2022 edition of Restoration magazine. It's about a case that's made its way to the Supreme Court, United States v. Merle Denezpi. Today, she's talking with us about this case and what it could mean for Indian country. Welcome, Mary.
Yeah, hello. Thanks so much for having me.
So, Mary, I want to start at the beginning. If you don't mind, can you help tell us who is Merle Denezpi? What is his crime? Which agencies are involved? Can you walk me through the timeline of all that's taken place so far?
Sure. So Merle Denezpi is a Native man. He is a criminal defendant in a case that has been prosecuted by the Mountain Ute tribe for acts of sexual assault, criminal sexual assault committed on the Mountain Ute reservation against a Native woman, a Native victim. The issue in this case, of course, involves double jeopardy. And in this case, the Mountain Ute tribe moved forward with prosecuting Mr. Denezpi in their tribal CFR court. And subsequent to that prosecution, there was a subsequent prosecution in the United States Attorney's Office involving the same conduct, the same criminal sexual assault. And so he has gone to the United States Supreme Court and asked the United States Supreme Court to overturn his conviction and prosecution in the federal court, in the United States District Court, on the basis that that second prosecution violates the U.S. Constitution's prohibition on double jeopardy.
Gotcha. And I feel like there's a number of players involved. It sounds like Ute Mountain tribes involved, the federal courts, Supreme Court. It echoes a lot of this sort of jurisdictional maze that we often hear about and talk about in our circles. Let's take a moment to talk about your article in the February 2022 edition of Restoration magazine. In the article, you and your associate Julie Combs at Pipestem and Nagel go over the Denezpi case, the issues, and the amicus brief filed by NIWRC. And it's my understanding that the amicus brief is now joined by the National Congress of American Indians. In the context of this case and this sort of jurisdictional maze that has come out of it, what's at stake for Indian country in the Denezpi case?
I think that tribal sovereignty is at stake because every tribe has the inherent right to protect its citizens from domestic violence and sexual assault. And that right should not be contingent on whether the tribe is utilizing a CFR court or is administering its own court. And I think anyone that understands the history of CFR courts knows that they were originally created as a method to infringe on the sovereignty of tribal nations, but that was many years ago, and really since the 1930s and subsequent congressional acts after the IRA, we've been witness to a Congress that has repeatedly acted to restore tribal sovereignty and jurisdiction and authority, not take it away. And so for the Supreme Court today to interpret that a tribe's ongoing use of a CFR court demonstrates that it really should not be able to exercise its inherent sovereignty in this way and prosecute a domestic violence or sexual assault crime committed on its own tribal lands in this way. Essentially to side with Mr. Denezpi in this case, the Supreme Court would have to conclude that when the Ute Mountain Ute tribe prosecuted Mr. Denezpi, that authority the tribe was using was a federal authority and not a tribal authority. And so at the end of the day, that conclusion would very much threaten the inherent sovereign right of our nations to protect our citizens on our own lands. And I think given the epidemic of violence that Native women and children face in Indian country, the violence that we're working, National Indigenous Women's Resource Center is working to end, we can't afford any infringement on that inherent right that our tribal nations have. We've already had too many infringements. We're working to restore fully that authority. And so I think the risk of losing a sliver of that authority here in this case is a real risk. And I think that's why I'm so thankful that NIWRC has filed its amicus brief in this case, and that the National Congress of American Indians decided to join the NIWRC in the filing of that brief.
I want to dig a little bit deeper into the amicus brief that you helped NIWRC file in this case. What does this amicus brief say and support? What are sort of the key points here?
The amicus brief really does what a lot of NIWRC's amicus briefs have done in the past, and that's educate the court on the epidemic of violence against Native women and children as a policy matter. And so the brief goes to great lengths to just sort of explain the contours of the crisis, but also connects that crisis to the inherent right of tribal nations to protect our women and children, and what is that connection between safety for Native women and children and sovereignty. And then our amicus brief really focuses on why CFR courts play a critical role in preserving safety for Native women and children for the tribes that continue to use CFR courts. And I think one thing that the brief points out that's just important to remember, Mr. Denezpi's argument is there's really no harm here to be had for Native victims because, if the Supreme Court accepts his argument and concludes that when he was prosecuted in CFR court, that was an exercise of federal authority, not tribal, that won't take away the right of the U.S. attorneys of the United States to still prosecute these crimes. We know at the end of the day that more often than not, the United States Attorney's Office does not prosecute violent crimes committed against our women and children when they happen on tribal lands. That's why we have a missing and murdered Indigenous women's crisis right now. That's why we have some of the highest rates of violence. And so to just kind of lean back and say, well, it's no problem if we limit tribal authority in this manner and conclude that it's actually federal authority because the feds are going to get it done. They're not getting the job done. And there's a real risk if the Supreme Court were to agree with him that for the tribes that utilize CFR courts, we're only going to see an increase in the kinds of violent crimes that Native women and children face on those tribal lands.
What else should people know about this case? What are some key facts, or what's the information that needs to come to light or that people should be paying close attention to?
It's a tragic case. I think anytime we have a domestic violence or sexual assault case against a Native woman or child, it's a tragedy because it goes against our values as Native people. It's not an intrinsic Native value in our various cultures to promote sexual violence against our Native women. It's unfortunate that it's, I think, through generations of violent federal policy, including, forced assimilation at boarding schools where our children were sexually assaulted and beaten. We have, because of these policies over generations, we do have sexual violence in our communities today. But the facts of this case are pretty tragic, and I think you can just kind of read the briefs that are being filed and learn about them to understand, that this is a real problem in a lot of our communities, and it's unfortunate, and that's why we have to protect the inherent right of our tribes to prosecute these crimes, regardless of whether it's in a tribal court or a CFR court.
So what's next in the Denezpi case? How can people listening stay updated on this case and sort of follow along with what's happening?
So the case has been set for oral argument on February 22nd. As of right now, my understanding is that that argument will go forward in person. Of course, with this pandemic, we never know, and anything can change in a moment's notice. Throughout the course of the pandemic, things have been rescheduled, things have gone online and virtual, but it does seem like the court is sort of moving forward with having in-person arguments. So the case will be argued on February 22nd, and then the decision will come out sometime before the end of the term, and the term ends at the end of June. Now, we don't know exactly when a decision will be published. It could be, any time after the argument, but usually it takes about a month to 2 months for a decision to come out. But sometimes, as we saw, for instance, in the Dollar General case, which was argued in December and the decision wasn't issued until the end of June, it can really take a while. Hopefully that will not be the case with this case, but we never know.
Sure, definitely have to just sort of keep our ear to the ground, so to speak, and just sort of follow what's happening. Well, thank you, Mary. This has been super helpful information. And as always, thank you for your incredible work on the Vabra Sovereignty Initiative and on the Denezpi case as well. We'll all be watching and listening for what happens next. And really just thank you for sharing your knowledge here on Speaking Our Truth.
Absolutely. And thank you for working on these incredibly important issues. And, I just appreciate all that NIWRC does to educate the Supreme Court on these issues. It's really important.
Thank you. For those listening and who want to read more about the Denezpi case, please be sure to read the 2022 February edition of Restoration magazine. It's available at nawrc.org/restoration. I am your host, Mallory Adamski with NAWRC. You can listen to more episodes of Speaking Our Truth Podcast for Change online at nawrc.org/podcast. To everyone out there listening, prayers out to all of you. Thank you for tuning in, and take care, everyone.